Thank you very much, Valeria, and thank you very much, Clive. Yes, I was very pleased to receive that award, Top 30 Under 30, 2 or 3 years ago. It was definitely one of the highlights of my career. I'm going to talk to you today about the Lloyd's Open Form 2011. In a sense, what I'm going to speak to you about is the legal and contractual side of what Roger Evans spoke about earlier, of the salvage industry. So before I go on to look at what the changes are to the Lloyd's Open Form, a quick overview of what the Lloyd's Open Form is and how it works, which it surprises me that many in the shipping industry, including quite a large number of owners, don't really understand. So I shall hopefully explain it very quickly. The Lloyd's Open Form is the most widely used form of salvage contract in the world, of true salvage contract. It has a long history. LOF has been in existence in various forms for over 100 years. A fundamental concept of the Lloyd's Open Form is the so-called no cure, no pay, which means if the ship and the other property, the cargo, are not salved, then the salvor doesn't get paid anything. It's interesting coming from London this week, because I've heard a rumour in Naples that Rafa Benitez is going to introduce a no cure, no pay football contract at Napoli, but I digress. The principle of no cure, no pay has been considerably changed in recent years by the introduction of the scopic clause, which allows the salvor, when there is a danger of oil pollution or damage to the environment, to trigger a tariff-based reward system, so they can still get a salvage award even in cases when they don't manage to save the ship and cargo. One of the issues that has been touched on by a number of speakers, particularly Roger Evans and Chris South, in terms of major casualties, is the ability to respond quickly, to minimise the damage to property and the environment. And one of the critical factors of the Lloyd's Open Form is that the amount the salvor is paid is fixed at a later date to reflect the value of the salvage services. That's really a critical point, because it means that the salvor can start immediately to provide the salvage services. There's not a standoff between the salvor and the ship owner. They're not sitting there for a number of days haggling over how much the salvor is going to be paid, which might lead to the ship being lost and oil pollution or other damage. So that's really a critical aspect of the Lloyd's Open Form. The awards are how much the salvor is paid is fixed by a Lloyd's salvage arbitrator, or of course can be agreed by the parties. Awards are based basically on the salvage convention. They take into account a number of relevant factors, including the length of the salvage services, the complexity of the salvage services, the cost of rendering those services to the salvor, the danger involved, and importantly, the value of the salved property. In other words, the ship and the cargo principally, possibly also bunkers and freight at risk. That means that awards can be a very high sum, certainly compared to a commercial towage contract or other form of contract. One example was an LOF case I did for an Italian owner, an Italian hull and machinery market, a relatively small chemical tanker that grounded in Holland with cargo on board, so there was a danger of pollution and of the ship breaking up. In that case, the salvage services lasted for a total of 45 minutes, and the salvor got $1.1 million salvage award. So that shows you that the value of property at risk is a critical factor. What really underlies the Lloyd's Open Form is a public policy of encouraging salvors and rewarding them for their efforts. And this again, in a way, reflects a lot of the comments speakers have made today. Again, I would say particularly Roger Evans and Chris South. So there are questions about how will we respond to a major container ship casualty. How will we deal with casualties promptly and effectively? And in a way, the bottom line answer to that is that we will do it by ensuring that salvors are properly rewarded for their services and they have sufficient money to invest in vessels, in training, in being able to respond. So in a way, the Lloyd's Open Form embodies and supports the salvage industry in a critical way. So that's really how the Lloyd's Open Form works and its principal features. The latest edition is the 2011 form. It's important to note, if you contract on a Lloyd's Open Form terms, if the salvage takes place and the contract is signed after LOF 2011 comes in, you must use that form. You can't choose an earlier version. You can't contract out of the current system. There are really two changes to the Lloyd's Open Form introduced by the 2011 form. The first one is said to be to do with transparency and consistency, and for the first time LOF salvage awards are publicly available. And secondly, there were two changes to salvage security in the way salvages are handled. The first was a right of salvage arbitrators to obtain security, and then there were a number of changes in dealing with salvages of container vessels and dealing with the cargo on board container vessels. So the first major change is that for the first time ever, Lloyd's Salvage Awards will be published on the Lloyd's website, so they are publicly accessible if you're a subscriber. It's also, if you use a Lloyd's Open Form, you should register that with Lloyd's. That is a huge change in the LOF system because it is a fundamental principle of English arbitration that arbitration proceedings, the materials and documents produced in the course of an arbitration and the awards are private and confidential to the parties. It's a right that is recognised and can be enforced at law. The alley shipping Corps shipyard Tregear case was a Court of Appeal case that I acted in, where the court gave an injunction preventing the use of an award and documents in one arbitration against one company, one ship company, in an arbitration involving a second one ship company owned by the same people. The problem with confidentiality of arbitrations, which is a valuable thing for ship owners, is that it clashes with another aspect of English jurisprudence, which is that English law is a common law system based on precedent. Because of that system, it's felt that English law will give you uniformity of decisions, certainty and predictability. If you have certainty and predictability, then legal disputes should be minimised and therefore legal costs should be kept to a minimum. But the problem is, if arbitration awards are private and confidential, then you don't have any precedents. And so you have the opposite effect. In salvage arbitrations, the parties don't know where they stand, they don't have certainty and predictability, therefore it leads to more litigation and more legal costs. And that is really what this fundamental change in the Lloyd's Open Form addresses. Now you will have a series of precedents, a series of jurisprudence and awards that can guide the parties and therefore minimise disputes. So it's a very substantial change. I just mentioned there the specific wording is Clause 3 of the notices and Clause 12 of the Lloyd's Standard Salvage and Arbitration Clauses. Two caveats to the change. The reality is that under the old system there was an unofficial system of disclosure and circulation of awards between arbitrators and lawyers and others involved. That has received judicial recognition in the Hampton case. The second important exception is that the Lloyd's Open Form 2011 does specify that there is a power of the arbitrator to withhold publication of the award if there is a good reason for doing so. And that can be on the application of either party, but at the moment there's no real guidance on what a good reason might be. The second substantial changes to Lloyd's Open Form is firstly it gives the salvage arbitrator a right to demand security for their own fees and expenses that have been incurred or that are anticipated from one or more of the parties. There's an identical provision for appeal arbitrators. The second major set of changes are to do with essentially container ships and containerized cargoes, which have led to very serious problems and difficulties and wasted costs of particularly large casualties where you may have hundreds or even several thousand cargo owners involved. A case like the MSC Napoli is a perfect example. In those sort of cases, it's led to a lot of difficulties for the salvors tracking down cargo owners, dealing with them, dealing with the salvage, and it's led to disproportionate costs. So there are three changes to the clauses that have been brought in. Clause 13 of the salvage and arbitration clauses states that a notice in relation to salved cargo which is not represented can be sent to the party or parties who have provided salvage security, and that is deemed to constitute proper notification to the owners of the property. So the insurers who have put up the bonds for release of the cargo, it's sufficient to notify them. You don't need to track down every single little cargo owner around the world. Clause 14 of the salvage clauses provides that, subject to the approval of the salvage arbitrator, where there's an agreement between the salvors and the owners of 75% of the value of the salved cargo that are represented, that agreement is binding on the owners of salved cargo that are not represented. Again, so effectively the salvor doesn't need to track down and get the specific agreement and negotiate and discuss with every cargo owner. They can bind the smaller cargo owners. And similarly, finally, clause 15 again says, subject to the approval of the salvage arbitrator, salved cargo with a value below an agreed figure can be omitted from the salved fund and excused from liability for salvage altogether if the costs of dealing with them is likely to be disproportionate. So these three, what seem quite technical and minor changes, actually lead to a very much more streamlined, efficient and cost-effective salvage process where there are large container vessels with a large number of cargo owners. So it's a practical change that will undoubtedly make the system a lot more effective. The final point I want to mention that is not a change introduced by the Lloyd's Open Form, but when the form was introduced, a new system was introduced for appointment to the LOF panel of arbitrators, and a new panel of arbitrators was appointed at the same time, which Lloyd said would make the process more transparent and inclusive, or as some Greek salvors insisted, it was all a conspiracy to reduce the amount salvors were paid. So that is basically what the Lloyd's Open Form is about and how it operates, and the important changes that have been brought about by the introduction of the new Lloyd's Open Form 2011, which will now govern any Lloyd's form salvage that it has entered into. Thank you very much. So on time.
Thank you, David.